Okay. It is exactly 8:30 p.m. Central Standard Time. It is Monday, November the 30th. And welcome to week number 4, week 4 already of constitutional law. So, and so I'm going to say something kind of funny right now, but make sure that those people who are prepared for my lecture that's going to take place on November the 31st, you get ready. But those are the same people also that say that they call me, text me, email me the 25th hour of the day. So, so it's kind of like the 30th of February, those kind of things. Everybody's got that. Yeah, I remember when I was a kid, I learned a poem. And the poem that I learned helped me win a case as a lawyer in court, actually. I had an instance where it was alleged that my client did something on April the 31st. And it was in the police report. It came across the stand. I actually asked the witness about it, and the witness said, "That's the definite date." I says, "Are you positive about that?" He says, "Yes, I'm positive about that." And so I said, "Are you sure?" So the state's attorney objected, asked and answered, and the judge says, "Move on, counselor." So, and the judge was smiling. So anyway, I said, "Okay." So then, I asked the police officer about it in their report. And I says, "It says the 31st of April. And that this is the guy that the witness had identified." So I said, "Okay." He says, "Well, I wrote down what the witness said." Okay. Well, when it came to closing argument, I argued to the jury that they had the wrong guy and that they were wrong. That both the prosecutor was wrong, both the witness for the prosecution and the report was inaccurate. And I said to the jury, "Ladies and gentlemen of the jury, when I was a kid, I learned this poem that my grandmother taught me. And it went just like this. It said, 30 days had September, April, June, and November. All the rest have 31 except the month of February." And the prosecution objection, and the judge says, "I'll allow it." And so I said to the jury, I says, "As you recall, the witness said that it was the 31st of April that my client did this incident, and that the officer read from their report an error." So anyway, so after I finished my closing argument, then the prosecution makes their rebuttal argument and says, "Don't be misled by Mr. Wright and the date. Yes, it was a mistake." Magical words to a defense attorney. I could have done, there's a dance called the Running Man. I felt like my cousin Vinny, hey. And so anyway, the bottom line is that the jury said that they discredited all of those people and said that they didn't have credibility. So anyway, I won that case because I knew that poem. That's why there are things that you learn in life when you become a criminal defense lawyer, you can use in court for real. And Vinny did it, and he did some stuff that's for real. That was pretty good. So that's a little something for you. So when you later on in your career, Rebecca. Get out there. You'll who knows? You may one day be able to use that. And it's just, I remember a professor told me, but seriously, it's the little things that we as defense attorneys use to win cases. We don't try to knock out. So yeah, yeah. As you remember, Al Wood said, "Did you see Legally Blonde? Did you see Legally Blonde?" Yeah. Remember at the graduation, she said, uh, "A very wise person told me." You remember when she was going to quit and give up because she had a jerk of a boss that she was working for that tried to hit on her, and she decided that she was not going to fit cut out, and then you remember she went to the beauty salon to tell her friend, and her friend is doing the hair of a professor that was a tough professor, a female professor, and she told her, if you're going to let one, whatever she said, stop you, you're not the girl I thought you were. Well, what you're going to say at the end is that, yeah, I remember a professor once told me. Okay. Uh, but you know what? You laugh, but I'm not kidding. There's some funny stories I have throughout my career. And then when I do my book, I'm going to put them in my book. Some little nuances that are common sense things that helped me to become successful as a criminal defense lawyer. Because I was talking to everyday people, remember, so I weren't talking to lawyers. I didn't like to do bench trials. I liked doing jury trials. 12 in the box, as we used to say. And I had a 90 percentile, as you heard me talk about that. If you, when you get a chance to listen to that story about my life, you'll hear. So anyway, meanwhile, back at the ranch here, let's share my screen here. And here we go. Okay, and so now we scroll on down, and then you'll have a chance to see the written assignment for week 4. Gant versus Arizona. It's a case. We'll talk about it more in detail. And so remember this, and you're going to remember what I say to you in addition to the rubric. Apply the rationale from Gant versus Arizona. Please remember to cite your case. Use the official site for Gant versus Arizona, which you'll see in a little while anyway. I one of the things that I'm really picky about, and I say this to my students all the time, and it's from my legal background, and you, having been a paralegal, would probably appreciate this, is that when you cite a case, you want to cite the source appropriately. Now, I've seen some students use Fine Law or Oyez or there's another one, I can't remember what it is. But I'm a person who prefers the official court citation, which goes something like the number in the U.S. for United States Supreme Court, and then the second is another number which represents the first page of the case. Or if you're making a point in citing a source, you'll put the page where that information is located, and then in parentheses you'll have the year of the case. But that's the official. And there's also other ways. The lawyer's edition, which is put out by West, has another way of citing it, and then so does the third one, I can't think of it, but they have a way of citing it too. But my preference is to teach my students to stick with the official court citation. And this is a United States Supreme Court case we're talking about. Answers the question, is this legal? You got to answer this in your paper. Don't say, yes, it's legal, and then be done with it. Or yes, or no, it's not legal, and then be done with it. That'd be very disappointing. So that constitutes 75 points out of the whole thing. And then the other 5 points have to do with APA and those requirements. Okay. But we'll talk about that a little bit more. Very interesting case, though. All right. And so now, current, remember you did relevant case last week. Before that, you chose a topic from the Fourth Amendment. And so now you're going to write on a current topic. Choose and describe the circumstance around a current case or event relevant to the Fourth Amendment. Professor Wright, I couldn't find any cases. I know better. Well, it was you who brought to my attention, what's it called? Fast case? Is that what it's called? Yep, fast case. I'm indebted to you for that, because I always say a student of mine gave me that information, and so I appreciate that a great deal, because I didn't know about it. Well, why wouldn't I know about it? Never been a paralegal student. Remember, I was a paralegal, but I was never a paralegal student, because when I came along as a paralegal, they called them law clerks, and there was no training, certificate, certification, and any of that stuff. So anyway, I learned it on the job. Okay. As they say, OTJT, that's on the job training. But which is something too that once you become a paralegal, you'll also implement that with what you learn academically as well when you get in trenches. Includes options and a short explanation of how the case fits into your overall paper. Include a thesis statement. Please, 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 please include your thesis statement at the beginning. I always tell students that a thesis statement is setting the pace for what you're about to write about. And your first statement, which consists of maybe 2, maybe 3 lines, basically sets the tone. And I read it. You don't have to even call it a thesis statement. There are students who do it, which is fine, but there are students who put it at the end and later call it that. I said, no. Write it as a thesis statement, so when you write your papers, by the way, all your papers should have a thesis statement at any rate. And then, of course, the APA requirements after that for a total of 100 points. Okay. So that's the assignments for that. Now, the live classroom lecture. Here we are, week 4. We have 2 more to go after this. And your student survey. All right, now up here, if you go up here in this class, okay, where is it? I know I put it in here. I know I put it in here. Where'd it go? It disappeared. Or did I put it in after? Wait a minute. Oh, there it is. Professor Wright's Adversity to Springboard Success video, which, as you have, this is the link, but you can even do this. And it will take you to the video, which you can't hear because I have my headphones on. I don't think so. Anyway. So anyway, so it's located in there. Did you hear me talking on that video when I had that, when I hit that? Did you? You did? Oh, okay. That's because I have it embedded. Okay. Since I have it embedded, then do it. All right. So anyway, it's here as well. And then I sent it by email to you guys as well. So make sure that you have a chance to sit down and listen to it. Have a cup of coffee or whatever it is that you drink to relax you a little bit as you enjoy this story about the challenges that I had along the way to becoming what I am today. Let's take a look at the course calendar real quick. Okay, so our course calendar, here we are. We're at the 30th. Of course, your reading assignment is there. Chapters 7 through 9. I sent you 7, 8, and 9 of the PowerPoints for you as well. And then your initial post, we're back to 2, which we'll have for week 5, week 4 and 5. Week 6 will return to 1 because of the final week. So anyway, your initial post on punishing police. We're going to talk about what that's all about. And then seizure or not. I want to talk about that. So then your initial posts are due tomorrow night, 11:59 p.m. Central Standard, and then Saturday the 5th. Believe it or not, it's December coming up tomorrow. So, all right, and then of course, as always, reminder of how close we are to the end. Notice this is where we are, and this is the last day of November. We got 2 more Mondays, and then the class ends on the 18th. Excuse me. And you know, your final assignments will be due the 18th, not the 19th, not the 20th, any of that. So it's very important. And so I always make sure that my students are aware of that. Very important thing so that you don't get complacent every week. I have had actually students that come back and say, I missed that. I said, you missed it every week? Okay. But anyway, that's another discussion. All right. Let's get to the course homepage again for my announcement for week 4, module 4, searches and seizures. As I said, chapters 7, 8, and 9 of the text and the PowerPoint sent. We're going to deal with the activity reasonable suspicion, probable cause, and warrants. And then these are your 2 discussion assignments, seizure or not, punishing the police. I already gave the deadlines. Gantt versus Arizona, and 4th Amendment project current topics. Pay close attention to rubrics and also what I say during it to support it. And then this is what I've been warning you about, adversity as a springboard to success. That's what that video will elaborate and explain to you. So, yeah. All right, this is one of the few weeks that week 3 and week 4 announcements show up at the same time, even though week 3 you already had it. The reason why is because it's 30 days in the month, and that's why. So just a little nuance here. So now let's get into the assignments. First, let's talk about the 4th Amendment project for this week, current topics. And if you notice, this matches what I said, except it adds a feature that you could miss, which is not in the rubric. And if they had me to put in there, I would do it, but they don't want you to tamper with the rubrics, so I don't. So page 1 to 2 pages minimum. Run your papers through Grammarly. You guys are pretty good about that. In fact, I think you guys I think you're certified in that area, right? Um, in Grammarly. Is that part of your position, Rebecca, to be able to help students with Grammarly? Oh, you're certified in APA. Okay. I thought that none of you guys are certified in Grammarly. Oh, okay. Well, yeah. Okay. Okay. All right. Well, you do have that information that can help students, because I've sent students to get help with how to utilize that, and then no one's come back and said they didn't learn, because you guys very smart anyway. So and we at the school certainly appreciate um, your ability to be able to help to have our students to be successful. So anyway, uh, run. A student of mine was very surprised in my criminal law class that he did a what was it? A flyer, and it said throughout the instructions, make sure the flyer is original, which means you could use some of the content from one that exists. But then this one came back as 62%. And he says, you ran the flyer through Grammarly? I said, yeah, because I wanted to see how original you were. And it actually, how it underscores, it shows you the stuff that's copied, and then it tells you in the column where it came from. So he said, so we weren't supposed to do that. I said, yeah, but remember, you have to offset that by critical thinking, adding, your spin on things. So he was shocked. He was shocked to find out that I did that. I says, "Hey, I'm a very thorough professor. I'm not going to mess around here. I run all your stuff through Grammarly except discussion posts." Which there are some professors that uh, do that, but I don't do that. Anyway, describe the circumstances surrounding the case or event as I've already shared. Include your opinions, as well as a short explanation of how it fits into your overall paper or the thesis in your paper. Include your thesis statement for your project. One or two main ideas, a thesis should represent the main idea in 1 to 2 sentences. There is no thesis paragraph that I know of, so it doesn't have to be that many. And then your paper should be proofread, of course, normally. And so there's nothing unusual in here that you have except the addition of the fact that it's 1 to 2 pages. Student asked me what happens if I go over 2 pages. I says, then I'll write excellent paper, very detailed analysis after I read through it and see and just throw some bunch of stuff in it. Or as one of my law professors, a guy by the name of Frank Wiggins, used to use the term gobbledygook. I think one of my students came up and brought that term out during one of my lectures last quarter or quarter before. It might have been in constitutional law, and they said gobbledygook, and I said, where did you get that from? And they were from Florida, I think it was. But anyway, we want to make sure that you do that, and then has to be a Word document. Students sometimes like to submit PDFs. I says, I can't edit. I can't run through Grammarly a PDF document, and I will put a 0 in there, and I'll give the student a chance to put it in there. But I've always had students at the end, when they get to week 6, and I've told them like week 1 or 2 that they needed to submit the document in the proper format. And they come back and they said, oh, it's after the course is over. Is it too late to submit it? I said, yes, it is too late. So anyway, Microsoft Word, it says it in there. Okay. And so you've got the rubric, and then if you click on this, you also get a reminder about the deadline and the number of points. All right. So that's that project. Now, Gantt versus Arizona. As you can see, there's the site right there. Gantt versus Arizona. I don't know why I keep saying Ohio. I guess I'm probably thinking of Terry or those Ohio cases, MAP v. Ohio Supreme Court cases, but which is a 2009 case that I kind of remember this case only because I had already retired, but I keep up with what the Supreme Court is saying in decisions, particularly involving criminal law. But I read their decisions, like the one I read the other day. It's not long. It's a per curiam decision from the Supreme Court about the issue of government being able to pass limitations on churches and synagogues, in numbers, and an argument about it being discriminatory because bars and some others are able to have more people. But I read these cases because I like to keep up with what the law is saying, and then I like to see how the makeup of the Supreme Court causes the swing of the law. I'm a student of that, so I always read those. So this 2009 case limited the search incident to an arrest exception to the warrant requirement. And so what you're going to do is you're going to research this case and apply the rationale in a 1 to 2 page paper, which is also APA as well. And here is the fact pattern here. And then the question is, this fact pattern that took place here, is it legal under Arizona versus Gantt, or actually the technical name is Gantt versus Arizona. Okay. Now you will be surprised though that in some state court cases, I mean not state court, lower court cases before it gets to Supreme Court, they might reverse the names. But anyway, the point of the matter is this Gantt v. Arizona that we utilize. Okay, and then here's the citation right there for you, so you don't have to go look it up. So then it tells you stuff that you're supposed to do already: proofread, grammar, and also you already know it's APA because the rubric says so. Okay, and then again it shows the number of points, 80, and the due date. Any questions on either of those two written assignments? Okay. And then the discussion, seizure or not. So you're going to take this fact pattern, and then for your discussion, answer, is the seizure proper under the law? Is the search legal? And explain your answer. What if Megan had run after the officer commanded her to stop? Could she have been charged with anything else? And then you say what that is. Would the officer have a right to arrest her then? So you're going to look at this and you're going to answer this. And I know how you answer a discussion post, Rebecca. Yours is a paper in itself, which is not a criticism, but that means you put your time and effort into it, and I appreciate that. So I do see people, they have one, like for example, they'll say, is the search proper under the law? Yes or no? And they'll say yes or no, and then is it legal? Yes or no? Explain your answer. It's because, and some real short answer given, not acceptable. And then if Megan had run, um, after the officer commander to stop, then what, and then little short answers. So I don't want that. Yeah, I want detailed answers, analytical. Yeah, that's good. That's good. I have to explain why I'm right and why you should think I am too. You know what? We call that in terms the power of persuasion. That's exactly what that is. And that's what you want to be in your arsenal as a lawyer. My wife says the same thing. And we've been married 27 years, coming up in July of next year. So yeah, so I mean, it's, have you have you have you seen this commercial? I have to digress of some things. Have you seen this commercial about this guy, and he's talking about uh, some product, and I see it mostly on CNN, but I've seen it on some other channels. And he's an ex-weatherman, and he's describing whatever it is that he's describing, possibility of so and so, and then he gets up and he says, puts his hands up like he's in front of the. If you ever, I know there's a green screen that you use because I've been in studios quite a bit in my life. And then he says, possibility of something. And his wife says, you're doing it again. Okay, I'll stop because it's a habit. But when you see it, you'll, have you ever seen it before? You seen that commercial? Yeah, so you know what I'm talking about. Well, I'm like this. My wife's, I says, well, okay, exactly. So what is it that you're trying to say? Could you clarify it? And my wife says, I understand. I know you hear that too. So I says, no, I'm just trying to get an understanding. Not as actually who we are. Yes, explain it to me. Okay, that kind of thing. So anyway, seizure or not, that's what this whole discussion is about. But yeah, that's all right. We make the world go round. I always say this during my sermons when I preach. I said that in all thy ways get an understanding. And that's what it says in the scriptures. And so my wife says, yeah, but not the way you do it. You skin a cat. I says, oh, that's cruelty to animals. What are you talking? But anyway, what do you think we should do with officers who conduct themselves and conduct unreasonable searches and seizures in violation of the Fourth Amendment? Now, here's the point. Do you think officers should be criminally prosecuted for violations of these basic freedoms? Explain your answers. I have my answers that I supplied. You guys will see them coming up in the next few days. But the whole point in a nutshell is whether they should be criminally prosecuted depends on intentionality and those kind of things. And I can tell you that here's a police officer, and this actually happened. This is a real case, and I represented a family that hired me to represent a family member. Well, the police came in, and they were searching for um, drugs and a person in the family that I ended up representing. Well, they took off of the mantelpiece the urn, that the ashes of one of their loved ones, and they took them out, they opened it up and turned it upside down and poured it out. So was that an unreasonable search and seizure in violation of the Fourth Amendment? Should that person be prosecuted criminally? Yes. Yes, and that's what we advocated. He never was, but there was a civil suit. But in those kinds of situations, should a person who goes looking for a bag of marijuana, um, go through the kitchen cabinets and all those things. Well, someone could say, well, yeah, it could be a bag in there. However, though, if it's not in the immediate possession of the person, but they go throughout the whole house. I had another instance where I represented um, a young man who um, was actually in jail waiting to be bailed out. And he wasn't. And there was and guns were found at a beauty shop that his mother operated, which is where the scene of my case, the double murder that I had, my very first criminal case that I had, which I won. And so anyway, the young man's mother called me up on a Saturday and said the police were at the house and they were looking for her son. Well, they didn't realize that he had been acquitted in the case that I had, but that he was in custody because he had a violation of parole and that he used a gun to in self-defense. So I won the case. And so what they did was they went throughout the house and they ransacked the house. So if they're looking for him, they took drawers out and stuff and turned it over. They broke lamps and stuff like that. I advocated that they should have been prosecuted criminally as well as civilly. So anyway, it depends. It depends. All right. So you're going to explain your answers to that as well. And then finally, your live classroom phrase that I will give you before the end of this night. So now let's get into the meat of what we're talking about, searches and seizures. I love this module because it is like the essence of the Fourth Amendment. And it goes all the way through to dealing with pat down warrants, exceptions to warrant requirement, consequences of Fourth Amendment violations, and the difference between probable cause and reasonable suspicion. So we're going to talk about that right now. So let's talk about probable cause. No warrant should issue except on reasonable suspicion. Is that right? I'm glad you said that. Thank you. I was going to say, don't let me get away with that just because I'm a professor. No, I did that purposely. It is based upon probable cause. Yeah, I guess that would have been like, what is he doing? You know, but we do that. That's that's what we do is we test students, and that's what I do anyway, to make sure that you're foundationally solid on what you know. Just because a person of authority says something, so it's just because you're at a high office or high position and you say something, that don't mean that it's to be accepted because that person in high office said it. They may not even know what the heck they're talking about. So I don't even want to get off on that discussion because I could spend the rest of the time and next week talking about that issue politically. But anyway, the point of the matter is that reasonable suspicion versus probable cause. So there is a real difference. You cannot have a warrant issued except you establish probable cause. And as it says here, they are not interchangeably. They refer to two different standards: as sure as beyond a reasonable doubt, and preponderance of the evidence are two different standards. Totally different. Okay. probable cause is closer to beyond a reasonable doubt. So anyway, let's talk about these and the features that fall under it. So for reasonable suspicion, that we're talking about stop and frisk. And when we start talking about, we call them Terry stops, from the infamous Terry versus Ohio 392 U.S. page 1 in 1968. An old case that when I was in high school that is foundational even to today's date in terms of the Fourth Amendment. So it's called the old stop and frisk case because that's the case that allowed a police officer to briefly stop an individual. And here are the 3 bullet points. If a reasonable person in the same circumstances could reasonably believe a person has been or about to be engaged in criminal activity, or as I heard once say, it's crime is afoot. If you read a Supreme Court case, you'll know where I got that from. But anyway, the fact of the matter is that a reasonable person would be able to say it appears that that person either is about to commit a crime or has committed a crime, one or the other, and all of the surrounding circumstances. Depends upon the totality of circumstances. That's my point number 2. And then finally, should be based on specific facts that you can share. So one of the features of the Terry stop, and the primary purpose of it, is for the protection of the officer, to pat that person down. So let's say, for example, you stop me, you ask me my name and so forth and so on, and then you tell me, you put my hands up and so forth, and you pat me, put your hands and pat down. I don't recommend guys do this with females. I've seen it because that could end up with a lawsuit. But anyway, if you're patting down a person of the same sex, and that individual is, you pat them down and you feel something bulky in their pocket. Now, if you were here in this room with me now, you might pat me down and say there's something bulky. Well, here it is. This is what it is. It's my wallet. Okay. You cannot use that as a basis to believe I have a weapon. Though I don't know if I threw this wallet at somebody. It doesn't have much money in it. It just got some cards and identification and other stuff in it. But anyway, the point of the matter is that, but if on the other hand, it could, but you could trip over it. But the other thing is, let's say you reach down, you pat down further, and then you says, oh, what's this? Okay, now, and I say, okay, these are keys. So I bring them out. Okay. So now then after that, then the officer says, oh, wait a minute, there's something around there. This is plastic in your pocket. Can you take that out? I said, no, I'm not taking that out. Can the officer go in my pocket then? Under these circumstances? No, because it's not a weapon. And that's how we're able to file what we call the infamous motion to suppress evidence of drugs, where it's a nickel bag or something like that, or either a marijuana joint is found, or a plastic bag of marijuana joints are found in somebody's pocket on one of those situations. So, excuse me, there is no evidence that that person has those things. On the other hand, if I pat the person down and I feel what appears to be a gun, now, the point of the matter is that I can say, would you take it out? And then they say, no, I'm not going to take it out. And then you reach and grab it. Then are you operating in a legal way? under Terry. Yeah, that's right, the right to disarm. And so that's how that works there in that situation. Let's shift over to the other side. Now, you need a warrant to either arrest or search someone unless there's an exception. And it's the higher standard. And again, remember the Terry stop is the reasonable person or reasonable officer standard. But the higher standard is there must be a reasonable belief that a person committed a crime. And it's also the same standard used for grand juries. And what that person needs to do is to go before a magistrate or judge with an affidavit eliciting facts that support their basis for believing that that person has committed a crime. And that affidavit is signed, and then the judge, if they're satisfied, will issue a warrant for that specific individual and or location, depending upon the circumstances. So let's say it says the right, and then here's what the Fourth Amendment says. So it says the right of the people to be secure in their persons, houses, papers, effects against unreasonable search and seizure shall not be violated, and no warrant issued but probable cause supported by oath or affirmation. That's what I was talking about, the affidavit, and describing the place and the persons or things as specific as possible. It's not a blanket thing. It's very narrowly interpreted and applied. So that's the difference between the two. So in order to make an arrest, enter a home, or conduct a search, there are exceptions. Now, the exceptions that I'm about to talk to you about are common sense, basically. And so these are things that we apply. And so there's 6 of them here. And these are the big ones. The first one is consent. So you don't have to have a warrant if a person consents to the search. An officer don't need a warrant. Consent must be voluntary. If I'm surrounding you with 3 or 4 police officers and I ask you, can I search you? And you say yes. Could that be considered as consensual, yes or no? Yep, you hit it right on the head. No, because first of all, number one, you can't do that. Consent must be free. It's just like utilizing the term that people who dealt a lot in, and I didn't do rape cases or sex cases, the question of was it consensual? Well, no means no. It doesn't mean now, not right now. No, it means what it says. And so the point of the matter is consent must be freely and voluntary given by the individual, not while they're high or out of it or those kind of things, not while they're in a position where they have no other choice. So consent must be freely and voluntarily. That's what the cases hold. And you can be rest assured that there are many cases out here where that's an argument made, but it must be voluntary. Okay. The search incident to an arrest. That's what we're going to be dealing with tonight in that paper. Once an arrest is made, that is, remember the arrest is made legally. That is upon probable cause, which, by the way, when you get to the Terry stop and you stop that and that person, then you get a weapon or something occurs during that brief stop that caused you to discover that that person has committed a crime, then it goes from the Terry stop to the probable cause, but the exception of search to once an arrest is made, conduct a warrantless search of the area in the arrestee's immediate surroundings for the purpose of the officer's safety or prevention of destruction of property. So that's what I was talking about earlier in the situation that where the person came and poured the ashes out and those kind of things, or they were looking for, searching for a person. Now they had, and they were looking for that individual, and they did things to intimidate the people. Is for, if it's not for officer safety or to prevent the destruction of evidence, it's not going to fall in search instant to an arrest. Now, I'm not going to read this next one because that's for you, but it talks about a little bit about Arizona versus Gant, or Gant versus Arizona, which you have the citation already here. There it is right there. All right. So you're going to be able to use that in your assignment. So I'm not going to do that because I'll be giving you, taking away from your ability to be able to research. I'm not going to spoon feed you with it. So then the third exception is what we call plain view. Now, what is plain view? All right. The police come to your house. You know, you let them in, and they come in and they're questioning you or talking to you or something, and then they see drugs on the table. And they didn't have to do anything. They didn't have to move anything. It was in what we call plain view. And so if they were legally in that place, so if they're searching an area with a warrant or consent from the owner, and the officer comes across contraband in their plain view, they can seize that without obtaining a warrant. And it makes sense because the material could be gone. How many times I remember we were doing drug raids and we were coming in the front door and the back door, and there was people in the bathroom. They weren't using the bathroom. They were flushing, and it was too funny. I remember a guy trying to flush down a whole bunch of marijuana down the toilet. And so he was in there. And so we said, open the door. And he says, no, because we saw him run in there. And we opened the door and we went in and we saw it. And he had a plunger. He was trying to plunge her because there was so much that it stopped up the toilet. It was just hilarious. I mean, it's one of those, oh God, when we were in court with that situation, I never forget that one there. But anyway, it was in plain view. And so, you know, that situation, which brings me to another exception in a few minutes. But if it's in plain view and you see it and those kind of things, all right, it's not that you're going, okay, you're entered into the house and you're standing there talking in the kitchen or in the living room area, and then all of a sudden you go into one of the bedrooms, or even you might even go into the washroom, but then you start looking under tubs. Now well, now it's coming back. There are tubs now that have legs, but before they went away from tubs with legs. But when I was a kid coming up, all tubs had legs, but now they have these modern tubs. My wife wants one with one of those the legs in there. You know what I'm talking about, where stuff can go under there and that kind of stuff. But anyway, if it's in plain view, it means what it says. plain view. The argument has been made, if an officer is in the house and then they smell marijuana in the house, and somebody said, is that considered as plain view? Well, there was an argument made that is plain smell, which is based on the experience of the officer in the house. If they were, allowed to be in the house, consensually, then in that case, there could possibly be some contraband in the vicinity. And and then they could, begin looking in the area for that as well. So anyway, that's a whole debate issue there. The automobile exception. The automobile exception. Automobiles are treated as mobile as they are, and things could be destroyed, so there's no need to go get a warrant where they have probable cause that there is evidence of a crime within a car. This also applies to mobile vehicles like boats. This rule is limited to areas where the contraband could be found. For example, if there is probable cause that a bicycle was stolen and in the trunk of the car that is searched, the officer can't open up the glove compartment. Because could you find a bicycle in the glove compartment? That'd be a little bitty bike or a big glove compartment. So it wouldn't fit within the exception there. So, you have to consider the circumstances there. Now, I remember I was at a seminar for the Illinois Chiefs of Police in Tinley Park, which every year I've gone to, except this year because of the COVID. And I remember they talked about this system that they had, that law enforcement was using to use social media to be able to arrest people for selling guns and drugs. And there was an instance where they had a person who was selling drugs out of their car. And so they saw it on their camera, and they did a GPS search, and this happened in Aurora. I know, Rebecca, you know about Aurora, and I know about Aurora because it's in our area here, that the police found out that the location of what they were looking at was the parking lot of the police department. The person was selling drugs out of their car, parked in the parking lot of a police department. So who would suspect that a person would be selling drugs out of their car in the parking lot of a police department? It was the Aurora Police Department. Well, anyway, they went down and they saw the lady, and they asked her if they could search her car. She said, no. They says, okay, we're going to place you under arrest, because they had already seen enough evidence. And so what they did was they shot off and got an electronic warrant, and they got it and searched the car, and sure enough, they found all kind of drugs in the trunk of the car, and so she got busted. But it was very interesting, very interesting. And so the question was, since this was an automobile, wouldn't it fall under the automobile exception? The reason why it did not is because the woman had actually, they had her to get out of the car. And when she got out of the car, they couldn't search the car because they already were going to place her under arrest, because they had evidence on video that she was distributing drugs, because people were coming up to the car and stuff like that. So, but that was that. But in the normal exception, they would not have to. But it was just really ironic. I mean, we were cracking up That audacity, I guess, is right up under their noses, literally. Exigent circumstances. This is kind of like what I was talking about a few minutes ago with the flushing of the drugs, where there is a threat to harm, emergency, or destruction of evidence can enter a premises without a warrant. So, but remember, we had to have been engaged in a chase or something like that. We can't just be um, passing by. Now, let me ask this question. If I'm passing by and you got your windows um, through the window, I can see you, um, with drugs on the table from the outside. Uh, do I have to go get a warrant? Yes or no? Okay, that's a good one. And the answer is it depends. That's what we learn in law school. It depends on the approach that is taken by the jurisdiction or the judge in that situation. So the point of the matter is we can argue that it was plain view. Okay, because we were outside, but we could see. We didn't have to like, stick our heads in, and then we just walk by in a big window, and you can see that taking place. So it's just like in on a window where you have mannequins and somebody's got a table full of drugs out there and they're doing their thing with drugs through the window. Can you go in and and arrest them? Well, the question is that plain view? Probably, probably. But there's arguments. There's arguments. Some say yes, some say no. That's what our law professor used to always tell us. And we have to, if we're going to justify it, then we have to have one of these exceptions that is arguably going to make some sense. So that's the beautiful part about the law is that it's ever changing. And one of the reasons it's ever changing is because a judge will rule a certain way, then another judge will rule a different way. Well, then that's usually resolved by appeals that eventually may take it up to the highest court in the land, or either if it's a state issue in the state where that occurred, their Supreme Court, and then it's determined. And then if there's a federal question, it can go to the United States, excuse me, Supreme Court, and those kind of things. So anyway, that was one I thought I'd throw at you and see, but that's why we lawyers are very cautious. That's why sometimes we don't give absolute answers to things. Not we try to avoid them, but we just know that there are variations. Stop and frisk, the last one, which we already know about. Stop and frisk if you have reasonable suspicion based upon articulable facts that the person has committed a crime or is committing a crime. And those are the exceptions. And so we come to the end of this session. Any questions? Okay. I like the Fourth Amendment because most of the ways that we defense lawyers defend our clients is to try to determine that the Fourth Amendment has been violated. The other way we use is the Fifth Amendment. And that was when we get into the interrogation and confessions, those kinds of things. But as far as as far as items are concerned, we use the Fourth Amendment, and we use things like fruit of the poisonous tree and stuff like that. That is a whole nother theory that I won't elaborate on tonight. So anyway, with that, I'm going to say good night. Any suggestions for a key phrase? I have one in mind. Take a shot at it. What do you think? No, we're not using that one. I think I either used that before. Um, nope, that's not it. That would be a good one. Yeah, I've used it. Adversity is a springboard to success. I've used that. Usually I use that during the first week of class when I would tell the story at the same time as I do that. And it would be a very long recording. It would last 2 hours or something. Hey, get that question mark off of there. Yeah, that's it. You got it. Probable cause. Give me that. That's it. That's it. And it actually, if you, a lot of students, if they figure me out, that a lot of times I'll, throughout the course of the lecture, mention a topic a lot. Well, in the Fourth Amendment, you can't get away with not mentioning probable cause because it's the overwhelming factor that gets you a warrant or arrest. So yes, probable cause, and that's it. So, all right, Rebecca, thank you so much again. I appreciate you coming out. Oh yeah, you and Ashley would have guesses every week. I never thought about that one. Uh, but yeah. Yeah. You know what? I used to give points to students when they got them right like that, but it wouldn't help you. Can't give it A+. Okay. You already are doing well. So, you know. So, professor, come on. Yeah, darn. That's right. So, all right. Again, thanks again for coming out again for week 4. I will see you next Monday. As we say, same bat time, same bat channel, 8:30 p.m. Central Standard Time. Get those assignments done. Still eating turkey? Hey, guess what? We didn't have turkey either. We had ham. Yes. Yeah. So we had honey baked. What kind of ham did you have? Well, yeah, I'm not a big turkey person either, but you know, what kind of ham? Did you have honey baked? Yeah, brown sugar, same family. Yeah, those are good. I love those. Those are really, really delicious. Yeah, we go and get those at Sam's or Walmart. You know what? I used to go to Honey Baked. Man, you pay an arm and a leg for the same one that you could go get at Sam's or either Walmart. So, but yeah, we were eating turkey sandwiches and I mean not turkey, I'm sorry, ham sandwiches and so forth and so on. But yeah, yummy. So, all right, well, good night to you, and I will see you next week. Stay safe and have an enjoyable week. Good night.